Good. How are you? How are you, friends and friends? Are we going to start? Yeah. Due to the issue widely known to all. Yeah. To this class in distance or virtual modality corresponding to the Notarial Practical Matter 2 of the notarial cycle that the Catholic University of Santa Fe dictates at the Posadas headquarters. As we see below, the theme or thematic block chosen to start is the one referring to the patrimonial regime of marriage and cohabitation. There is little that we synthesize in that sentence that we see there: this of mine, yours, ours. What will be the method to follow? The development of this thematic block. For it, if I wanted to show you, like on the show, own matter. Yes, from our notarial practice. 2. The patrimonial theme of marriage is contemplated, but minimally, yes. Some isolated topics are not linked, and which can lead us to make you lose the overall vision. It is project, thus, the little program of the notarial practice 2, and they warn how the issues are seen. For example, the one referring to liquidation of conjugal partnership, where he asks us to talk about the formalities of enabling documents, and also the one referring to extrajudicial partition, where he again asks us the question of formalities and different assumptions. It is clear that these topics are going to be dealt with and in this thematic block that we are going to begin to develop, but we are going to do it following the teaching criteria, the didactic criteria, the following guide. Yeah. Thus we see then the integrality or the general approach of the subject. Hence, we already give the owner the property regime of marriage and cohabitation. So, for that purpose, for example, let's see at the beginning if it refers to the methodological aspect. We are going to make a comparison between the Velazano Civil Code, how it treated the patrimonial question of marriage, and then we are going to compare how it was treated from the methodological point of view by the new Civil and Commercial Code. Year 2015. Then we will continue with what refers to marriage conventions, if the so-called pacts or prenuptial agreements. Institute. Although it is not new for Argentine civil or private law, since Don Dalmacio Vélez Sarsfield already foresaw them originally in his code, they have had little application in practice. Yes, due to their somewhat deficient regulation and, above all, due to the limited dissemination of the existence of the aforementioned institute. We are going to study how this new Civil and Commercial Code empowers them. If you revitalize them, you increase the number of possible items that can be dumped into them. And we hope that with daily life and with the passage of time they will make it an institute to which residents and individuals attend more regularly. We continue with the purpose of this guide as a simple preview so that you have a global vision of everything that we are going to study. We are going to delve into that third point in the analysis of the so-called primary system or primary regime. Yeah. What is the importance of studying this system? It will be next. Said system will be applied both to the community regime and also to the spouses who choose for themselves the property separation regime. Yeah. Hence, ultimately it is applicable to both patrimonial regimes. Yeah. Then we are going to fully immerse ourselves in the classic regime that we have studied throughout the law degree, when studying family law, and we began to study, to develop the patrimonial face of marriage, and we have all studied at the time, yes, as students. Now notaries. Future professionals, notaries. We studied in the degree in law, the community regime. We are going to review the main guidelines again. Yes, since, ultimately, today it is one of the possible patrimonial regimes to which to resort to regulate the patrimonial aspects of marriage. And we are going to see then these delimitation and distinction criteria for own and community property. And what is the importance of this distinction, both at the time of management and later at the time of liquidation of the community? And we are going to study controversial cases that we name in the guide with the name of borderline cases, that is to say, that it gives to think, or that they are owned, or that they are community property, or that they are partly their own, part community property. We are going to study precisely what are the guidelines that the code itself gives us to make an accurate qualification and not make mistakes in that attempt. And regarding that community regime, we are also going to study the causes of dissolution of the community. Yes, a community that traditionally dissolved under the old system, dissolved itself either by death or by divorce. And we are going to see how today there will be a voluntary cause of dissolution of the community regime and without extinction of the marriage bond. Good. Then we are also going to study a very interesting subject, with a lot of application. Peace. Notarial praxis such as the issue of the division of community assets, that is, the division of the assets. In what way should it be done? What prerequisites must be requested? Yes, and we will see with an overflight, since it is a topic more appropriate for the lawyer legal operator. The question referred to the system of rewards, a system that is applied at the time of dissolving the so-called community of the other regime, to the new regime in quotes that refers to the system or regime of separation. Of assets. Let's do a characterization. We are going to study and learn how goods are called. In this regiment, what are the grounds for its termination? And we are going to see that with respect to a community regime, although the spouses are going to find themselves with a light regime, yes, in terms of the control and management of the assets of each one of them, it must not be forgotten that, despite the fact that the spouses continue to choose separation of property, the primary system is applicable to them. Let's not forget about that issue. We are going to close the thematic block with the analysis of cohabitation unions. If what was called in the context of the community the concubinage. If today we know the technical denomination convivial union, if we are going to characterize them, we are going to study the importance of registering them, and if in any case there is some other means of proof with which it can be prove its existence. We are also going to see what refers to the so-called coexistence pacts that the legislation provides for, and we will see if they may actually have daily practical importance or not. Yeah. And finally, we are also going to study what are the causes of termination of the so-called cohabitation union. Good. In that intelligent, yeah. Let's start then. Next. Develop the referred. The first topic that we anticipated in the guide was the methodological question of making that comparison between the Vélez Code and the Civil and Commercial Code. Valid since August 2015. Well, let's go then to the analysis of the same code. We remind you that it had or possessed 4 books, the second book being the one referring to personal rights in civil relations. Second book, which had 3 sections. The first section referred to obligations. The second section, that we have studied everything in the long-awaited and beloved civil law. General part referring to the facts and legal acts. And the third section regarding contracts. This third section of contracts, in turn, is subdivided into 18 titles, the first of which is dedicated to contracts in general and the remaining titles to each typified contract in particular. At the same time, the second title was dedicated by Mr. Dalmacio Vélez Sarsfield to the so-called conjugal society or conjugal society agreement, regulated in Articles 1217, 1322 your Civil Code. We then notice the temperament that Don Vélez Sarsfield gives to the patrimonial question of marriage, that is, a contractual approach to corruption. With Dalmatius Eliezer, faithful understood this patrimonial aspect of marriage by a contractual approach as if it were or as if it were another contract. We come here to our days. If we locate Law 26994 sanctioned by the National Congress at the end of October 2014. According to said law, it was originally to come into force on January 1, 2016, and by subsequent law its validity was anticipated. Its entry into force on August 1, 2015. This code consists of 6 books, the second book being the one dedicated to family relations. If there is something that we should highlight about the new Civil and Commercial Code, it is its purity or methodological cleanliness in the treatment or order or organization of the issues. See how prolixity at the time of subdividing the titles of that book. Second of family relations. And we find that then said book has 8 titles, 2 of them being the ones that interest us in particular for the block that we intend to develop. This is the second title referring to the patrimonial regime of marriage and the third title referring to confidential unions. We deepen then the title. Second, if the patrimonial regime of the marriage, regulated in Articles 446 to 508 of the Civil and Commercial Code. We are going to notice how this second title is subdivided into 3 chapters. Chapter 1, referring to the general provisions. Chapter 2, referred to the community regime. And Chapter 3, referring to the regime of separation of assets. We highlight the following. The subdivision that is made of this title in its 7 chapters is not capricious. Since Chapter 1. Where are these general provisions? As we anticipate, it is applicable to the 2 patrimonial regimes regulated in the Civil and Commercial Code. That is to say, so much for Chapter 2. That is to say, the community regime as to Chapter 3 referred to the regime of separation of assets. What issues, for example, are found? Hoisting regulations regulated in these general provisions, yes, and highlighting that they have an imperative nature and are inexorably applicable to all spouses. They have no way of abstracting themselves from leaving their field of application. This is no field. For the use or application of the autonomy of the will always be applicable to you. That is to say, that, for example, an issue is regulated. For example, it is called assent. And assent for the rights to the provision of the rights on the regulated family home, regulated in Article 456 of the Code. Come on, let's get familiar with the logic of the new code little by little. In the new Civil and Commercial Code there will be 3 classes of assent, 2 of them applicable to marriage and the rest applicable to cohabitation. Good. So, for example, in these general provisions there will be a specific regulation for one of these types of assent. I reiterate my agreement. For the imposition of rights on the family home. Article 456. Another issue that will be regulated in these general provisions to the liability system in a certain way, is not so important for notarial practice. But boy does it have it for the lawyer legal operator. Yeah. Another issue that is also regulated there refers to the empowerment of powers that the spouses may grant to each other. There will be a specific regulation that will establish some characters and some limitations when it comes to granting powers. When between each other as all those issues. We highlight once again that they are applicable to the community regime or the separation of property regime. Well, finally, if we dig deeper into the 3rd title of that book, Second of Family Relations. Yeah. It turns out that we had anticipated that it refers to commercial unions today regulated in Articles 509 to 528 of the Code. That 3rd title is subdivided into 4 chapters. Chapter 1, referring to Constitution and Proof. Chapter 2 refers to the coexistence agreements and Chapter 3 refers to the effects. That the coexistence unions is during the coexistence and the referred Chapter 4. To the subject of the effects at the moment of the cessation of the food. And we have manifested and anticipated in a certain way in what we are going to deepen later on in terms of coexistence. For example, under a certain case and under a certain requirement, it will be enforceable within the world or notarial practice. The granting of a type or class of assent. And we could call or say in a certain way a convivial feeling. For the disposition of what we are going to study later. certain class of goods and under certain circumstances we are fine. This is the challenge that we are going to begin to develop and that we are going to highlight in the videos that follow.